just a couple of quick statistics. The blue bar at the bottom is industrial accidents. The maroon bar across the middle is transport accidents, and the white bars are the rest. And they're 4 years in a row. The longest and the tallest bar is last year. And I can't explain why it looks as if TAC complaints about practitioners dealing with TAC cases appears to have dropped off. I'm not sure that that's right. It may be that we're recording them differently and we don't need to distinguish between a TAC complaint about a personal injuries practitioner and a public liability complaint. So I'm not sure that there's anything of great consequence in those statistics. But probably this should comfort you. The tiny blue bar at the bottom is personal injuries complaints, or complaints against personal injuries practitioners, and the maroon bar is all other complaints. So I'm not presenting to you that the area of personal injuries is a high risk area. It's a moderately common area for complaints to be received, but by far the largest area is family law, and would we say property and conveyancing as well, Angela or Sarah?
Wills and estates.
Speak up.
Wills and estates and probate matters.
And wills and estates.
Yeah. But conveyancing, I think, is a big area that we get complaints about because of the sheer number of transactions that are going on.
Okay. Although Stuart introduced Angela and Sarah, you won't know that Angela is sitting in the middle and Sarah Lefleen is sitting on the wings, and what I want to do is ask each of them to interrupt me while I'm talking. I'll interrupt them, and you're welcome to ask questions or propose suggestions if you want to. The first case I want to talk about is a case it's reported in VCAT. The other cases I'll talk about are really cases we've got on our books that haven't had a court result, but they teach us lessons about ethics and conduct that we think are probably worthwhile for you. But the McChrystal case involves a practitioner who is a very competent, well-trained, experienced lawyer who was delivered to either, this was regional, but it can be a suburban practice of the firm that he worked for, or a rural practice to run the rural operation. And the case involves information being drawn to the regulator's attention as a result of a random trust account inspection. So we can have our attention drawn to a problem by either a complaint from a client, or by a complaint that comes through another third source that prompts us to arrange for a trust account inspection, or a complaint to the Law Institute that prompts them to recommend we arrange for a trust account inspection. Or it can involve discoveries arising out of a random trust account inspection. So all practices are randomly inspected by trust account inspectors without them having any basis for necessarily going into the firm. And this case arose out of that sort of an inspection, where the practitioner was billing clients for disbursements and receiving payment for disbursements, but was paying them straight into the office account. The bills were for barristers' fees in personal injuries matters and for an ergonomics consultant fees. Had billed and received payments, but had failed to forward that on when the solicitor received the payment. Didn't put it into trust, put it straight into office. The pressure that prompted the practitioner to make this terrible mistake was that he, in his operation in rural Victoria, being a sort of substation of a much bigger firm, was under pressure to reduce the overdraft. Not by the regulator, of course, but either by the bank or by the head office. And I think it's an important case for us to draw to your attention because this could happen to any of you, that you are part of a bigger organisation, you are very competent practitioners, you are set out into an outstation operation and effectively running an independent managed arrangement where you make some terrible mistakes because you're out of your depth managing your finances, your accounting and your trust account obligations. The outcome of this case was that the VCAT found that this practitioner had inadequate management training. So that reflects poorly both on the practitioner who is the subject of this case and the supervisors and the partners of the law firm. The person was overwhelmed by a workload. He showed remorse. In fact, he was so helpful during the trust account inspection that he identified 2 or 3 anomalies that not even the trust account inspectors had identified. And so he had good character. He had immediately realised he made a terrible mistake. But the court has said that you never have an excuse to break the law and the rules relating to trust accounts and money. Or any other critical aspect of the law and the rules that you operate under. So this practitioner has a misconduct finding against him and a $25,000 fine. And what it does do, it reveals to us the significant vulnerabilities that exist when you're out of your depth. There are high expectations about what you'll achieve for your colleagues or your partners, and you make some shocking decisions on either no advice or bad advice. I wonder whether Angela or Sarah have got any comment about the case.
Well, I have a little bit more to add to that because part of the shocking decision was to draw 42 cheques and then not present them, so they were classed as unsent cheques. Those cheques were drawn over a period of 18 months, and the sum amounted to $45,000. So it was a significant sum, and we refer to these cases as the checks in the drawer cases, and it's not the only one of its kind that's being heard at the tribunal and being decided at the tribunal. I think it's also important to note that, as Michael said, this matter was brought to our attention through a random trust account inspection. That is one way, as you said, of complaints or these matters being brought to our attention. There are similar cases that have been heard at the tribunal, in the former legal profession tribunal, and those were brought about by a trust account inspection that was, asked to be performed by partners at a particular firm because they were concerned about one of the salaried partners being arrested on tax office breaches, and other matters are also brought to us by barristers, often complaining that they know that clients have actually paid their fees, but the solicitors haven't forwarded those fees to them. So there are a number of ways in which we find out about these, and it's not always your own client who needs to complain about these matters. Anybody can lodge complaints against legal practitioners.
And there are also dozens of places a practitioner can go to for advice. Before you get in too deep, there's another case that Angela or Sarah will talk about where the practitioner got in deeper and deeper and deeper, made some terrible decisions. I think, from a regulator's point of view, our powers of forgiveness are far more effective than our powers of prosecution. So I'd much rather leave you with the impression that this sort of case that I've just described is one of those 8 that come in every day that are the exception rather than the norm. Starting point for not getting yourself into such a difficult ethical condition or situation is to ask questions, and if you feel so compelled, speak to the regulator. Of course you would go to the decision makers or the supervisors in your law firm, but what I'm encouraging with the Law Institute and with my office is to operate as a service desk as well as a regulator, so that there are opportunities for you checking answers to questions that you may not know. And of course, probably you're not going to use us as your first port of call, because you don't really usually ring the tax office to find out whether you're going to be pinged for tax evasion or not. So I'd understand that you probably wouldn't think of us as the first port of call, but I do want to get across the impression that I'm responsible for turning over these complaints and these concerns, and I'm not here to take your practising certificate off you, or have you pinged for misconduct, or fine you for $25,000 if I can avoid it. And so early intervention is probably a good lesson. Now, Angela Barrick, you've got this case involving a real estate agent and a solicitor. Do you want to talk us through it?
Yeah. This is a matter that's still being investigated, so I won't mention any names. It started off as a fairly simple transaction, and I think it may be common practice for a real estate agent to refer a vendor to a solicitor and ask them to prepare a contract of sale. That's actually what happened in this particular case. The solicitor prepared the contract, sent them back to the agent. The house was sold, and then the solicitor received a letter from the real estate agent saying, the house is sold, here's the contract note and the executed contract of sale, and you're now acting for the purchaser and the vendor. So the solicitor said okay, and started acting for both parties. Now, I'm sure you are all aware that there are some instances where you can act for both parties, but the rules are very clear on what you need to do and who you need to satisfy, basically. So the solicitor in this case did not prepare an acknowledgement, did not get a written agreement by the parties, did not write to them and tell them of potential disadvantages where that could come about with him acting for both parties. So he didn't satisfy any of those boxes, and technically he was acting in a conflict. He was acting for both parties.